Good afternoon, everyone. It's great to see you. There's plenty of seats, so please make yourself at home. Before we start, I want to thank the Dean's Office for their generous support of the Harvard Law School Library Lunch Book Talks. Copies of today's book are on sale outside of the room. I think John and Ben will stick around and sign them if you'd like to get a signed copy. So my name is Jocelyn Kennedy. I'm the executive director here at the Harvard Law School Library, and it's my great pleasure to introduce today's panel and our authors of today's book, Recognizing Wrongs. John Cp Goldberg is the Carter Professor of General Jurisprudence and Deputy Dean here at Harvard Law School. He's an expert in tort law, theory, and political philosophy. He's an associate reporter for the American Law Institute's Fourth Restatement of Property and an advisor of the Third Restatement of Torts. He's a graduate of NYU School of Law and clerked for the Supreme Court Justice Byron White. Having a hard time talking today. Benjamin C. Zipursky is the James H. Quinn 49 Chair in Legal Ethics at Fordham School of Law. Professor Zipursky is a leading scholar in torts, jurisprudence, and legal ethics. He publishes widely on subjects ranging from punitive damages and conflicts in interest in mass tort litigation to the varieties of pragmatism within legal philosophy. A longtime co-author with Professor Goldberg, together they co-authored a leading case book, Torts, Responsibility, and Redress, with Anthony Sabak, and the Oxford Introductions to Law Torts. Also a graduate of NYU School of Law, he clerked for Judge Kimball Wood of the United States District Court, Southern District of New York. Joining our authors today to comment on Recognizing Wrongs are Professor Noah Feldman, the Felix Frankfurter Professor of Law and Director of the Julis-Rabinowitz Program on Jewish and Israeli Law. Professor Feldman specializes in constitutional studies with a particular emphasis on the relationship between law and religion, free speech, constitutional design, and history of legal theory. He served as a senior constitutional advisor to the Coalition Provisional Authority in Iraq and subsequently advised members of the Iraqi Governing Council on drafting its interim constitution. He's written 8 books and co-authored 2 textbooks. A graduate of Yale Law School, Professor Feldman clerked for Supreme Court Justice David H. Souter, who's one of my favorites because we're both from New Hampshire. Which is a good reason to like a judge. Professor Danielle K. Citron of Boston University writes in the areas of information privacy, free expression, and civil rights. She was named a MacArthur Fellow in 2019 based on her work on cyber stalking and sexual privacy. She's the Vice President of the Cyber Civil Rights Initiative and serves on numerous boards and advises tech companies on online safety and civil liberties, as well as advising federal, state, and international lawmakers on privacy issues. She is a member of the American Law Institute, serving as an advisor, serving as an advisor to the Restatement Third Information Privacy Principles Project and Restatement Third Torts, Defamation, and Privacy. She's a graduate of Fordham University School of Law. And Professor Frank Michelman is the Robert Walmsley University Professor Emeritus. He has published widely in the fields of constitutional law and theory, comparative constitutionalism, South African constitutionalism, property law and theory, local government law, and general legal theory. He is a fellow of the American Academy of Arts and Sciences and past president of the American Society for Political and Legal Philosophy. He has served on the Committee of Directors for the Prague Conference on Philosophy and the Social Sciences, the Board of Directors of the United States Association of Constitutional Law, and the National Advisory Board of the American Constitutional Society. In 2005, he was awarded the American Philosophical Society's Phillips Prize in Jurisprudence, and in 2004, the Brigham Canner Property Rights Prize. So without further ado, I'll turn it over to our panel to get started talking about recognizing wrongs.
Thank you, Jocelyn. I'm going to turn it over to Frank in 1 second. I just wanted to say thanks very much to Jocelyn, to the library, and to the law school for putting on this lovely event, and thank you all for taking the time to be here. We're going to make this easy. We're going to go in spatial order. So Frank is going to start us off with some comments, then Danielle, then Noah, and then Ben and I will try to salvage what's left after the commentary.
Okay, John, thanks. It's really a pleasure to be here to do this. I love this book, and I can't stop now to count the ways, but
It's a good time to do that.
Yeah.
I'm more a public law guy than private law. And to me, the most interesting feature of this book is the bridge that it builds between public and private law theory. It does it by treating tort law, rightly understood, as a matter not just of good policy, but of basic political legitimacy. We'll start with what the book means by tort law rightly understood. People in free societies put up every day with setbacks and hurts from the free conduct of other people, but we don't do that without limit. Some selected instances are socially recognized as wrongs done to the injured party by an injuring party. And our tort law, say John and Ben, is law for the redress of those wrongs. It's our system's provision for a power of civil recourse, as they call it, for sufferers of wrongs for redress against the related wrongdoers. Well, John and Ben don't claim this redress for wrongs account as their report of some platonic form for tort law. They offer it rather as the best interpretative account of our tort law as we find it actually going on. And of course, they mean their account as highly contentious against some others in the field. And as one plank in support of their account, they say that at stake here is nothing less than political legitimacy itself. Provision for civil recourse for redress of wrongs, they argue, is a requisite part of the basic structure of any polity that aspires to legitimacy on, broadly speaking, liberal terms. Well, you may already pick this up from the lingo, basic structure. What's interesting for me is how this argument from legitimacy sounds as a theme from the philosophy of John Rawls. Our authors do notice some parallels in the book with Rawlsian thought, but I want to take that further. I think that some of the meatiest sections of the book, sections fleshing out what the authors call the constructivist nature of common law judging in the tort field, may be more distinctively Rawlsian than they perhaps have yet supposed. To explain, I first have to say something about the idea of wrong as it figures in this book. A wrong, as our authors mean it, does not occur with every bit of injurious conduct and breach of positive legal rules. They aren't claiming, utterly implausibly, that a basic structure fails of liberal legitimacy if it lacks civil recourse for any and every injury traceable to positive legal violation. Their much more gripping claim is that legitimacy fails if recourse is lacking for conduct widely recognized as in breach of common duties owed to others not to hurt them. What counts as a wrong here can only be known with the aid of morally tempered considerations prior to positive law. Now I go back to legitimacy. Like Rawls, our authors here equate political legitimacy with a society's having in place a basic structure. We can call it roughly a constitution, a composition of basic framework institutions, arrangements, and norms, which can make justifiable to all citizens a subjection of all to the coercive force of laws approved by some or most, but perhaps deeply opposed by others. For Rawls, chief among the requisites for such a constitution is a guarantee for protection of basic liberty, as that has been known to the constitutional democratic tradition. Goldberg and Zipursky would add to that a guarantee of civil recourse for redress of wrongs. But then both Rawls and our authors face the need to thread a path through dangers from both excessive concreteness and excessive abstraction in the basic structural terms of guarantee. That is, basic liberty for Rawls and redress for wrongs for the book. I'll let Rawls lead the way. He saw how a constitutional guarantee respecting liberty could not work to reconcile dissenters to controversial ground-level laws unless that guarantee spoke with a certain measure of abstraction from the concrete policies it was meant to transcend or vault us past. But Rawls also, and quite distinctively, saw how too much abstraction would defeat the project of justification. A constitution containing just a single sentence of guarantee against, say, infringement of basic liberty, leaving courts to decide from case to case which laws fall under that ban, could not meet the needs. It would just be asking constituents to sign a blank check. Rawls's thought was that a constitution with a list of guarantees of familiarly named liberties, conscience, expression, association, security of the person, due process, and so on, might possibly do it. For suppose the citizens could further depend on the judiciary's sharing with them an immersion in a wide but still resonant political culture or tradition. For Rawls, that would be constitutional democracy. Put that together with the tethering of the courts to a list of named common liberties, and the combination could possibly, Rawls hoped, provide sufficient assurance of a resulting scope of liberty protection that all or nearly all could find acceptable, if also sure to depart in some cases from one's own convictions of true rightness. Well, you might or might not think Rawls found a good solution to the problem. My suggestion for now is only that John and Ben are quite visibly, at least to me, following suit. A basic structural guarantee respecting civil recourse for redress of wrongs can't bolster political legitimacy if wrong is the only term of guidance supplied to the courts running the system. That would be like a Rawlsian constitution saying only basic liberty instead of the list, on which Rawls, I think, for this very reason, insisted. And now, lo and behold, what do we find in the book? We find our tort law being congratulated for, and our author's redress-centered account of it claiming confirmation from, its articulation of wrong into what the book beautifully calls a gallery of injurious wrongs. The doctrines and discourse of our tort law, the authors repeatedly press on us, distinguish among personal, property, and dignitary torts. The law's talk is not of wrongs generically, but of assaults, batteries, defamations, frauds, malpractice, nuisances, trespasses, negligence, and defective products. And still torts, they say, are altogether cognizable as a certain type of wrong. Well, what type? What I've just given you is a list, not a type. For an answer to that question, John and Ben say academic moral theory would be the wrong place to look. People do get how the itemized torts make a package of wrongs, but not by the way of moral theory, rather by the way of sensibilities drawn from life in our society. Most of us, the authors say, having been instructed from an early age to refrain from these ways of injuring those aspects of other people's well-being. But it's a these and those, it's a pointing that goes on here. So, torts are neither one wrong nor a hodgepodge. They're a gallery, like an art gallery. I take it that's what gallery is meant to evoke here, with pictures organized into rooms. Even as occasionally new rooms are added, the gallery retains a structure, and the structure is what can give customers their confidence in the gallery's integrity and truthfulness to its calling. And yet the concordance of the arrangement to the sensibilities of the customers is all we know how to say the structure is. The gallery is thus, in the author's word, drawn from the field of moral epistemology, a constructivist project. That's Rawls's word too. This book's constructivism, ensconced in a conception of political legitimacy, is to me a very close relative of the so-called political constructivism of John Rawls. Goldberg's and Zipursky's early age instruction plays the same perceptually integrative role here for wrong as the constitutional democratic tradition plays for Rawls in his articulation of liberty into liberties, where, in both cases, articulation into an itemized list of a generic justificatory idea, liberty into liberties, wrong into the torts, is our only possible way to give that idea, the sufficiency of concrete substance that justificatory traction requires, that is, for legitimacy. So that's my story, and I'm not the only person in this room who knows anything about the philosophy of John Rawls, and what I'm thinking is there may be people in this room who would be thinking something like, well, Michelman has given us his interpretation of Rawls as an interpretation of Zipursky's and Goldberg's interpretation of tort law.
So I'm glad I follow you, Frank, because I'm going to take some of those concerns about the indeterminateness of what a wrong is and fill it in, that vacuum, with some concrete inspiration that the work of Ben and John have supplied. So I'm sort of a proof of concept in my work on cyber civil rights, and then I'm going to have some critiques, of course, and have us think about how the recognition of wrongs can not only inform substance, but also procedure. Okay, so just quick fun thing. Read the book, guys, for all of our students in the room, because there are some of these delightful passages, and one of them for tort students, in which you say, saying that tort law is a law of wrongs is like fighting words to tort scholars. And I have to say, I had firsthand experience. As a very, a young academic in 2005, I wrote a piece about insecure databases of ultra-sensitive information. And I'd made the argument that we understand torts as norm setting, right? What is wrongful conduct in empowering victims? And I had a colleague who I adore at University of Maryland call me into his office and say, no one will ever take you seriously in the academy if you ever say that tort law is a law of wrongs and not about efficient deterrence or setting prices. So they're not kidding. There's also a wonderful endnote with Yoda, do or do not, there is no try. Find that in any other sort of whimsical tort book, I don't think you will. So in any event, it's a delightful read. And so let me talk a little bit about why I say sort of cyber civil rights is a proof of concept. So in their book, John and Ben argue that that tort law should be understood and the recognition of wrongs as part of our guarantee for equality, for fairness, and for individual sovereignty. And they recognize that, at least for feminist legal scholars in the late 1970s, early 80s, that the notion that tort law should play an indispensable role in the fight for equality was in some sense dismissed. Dismissed in part because, as they recognize, they were worried that judges, who were mostly male and mostly white men, wouldn't be able to recognize or would refuse to see within tort law the workplaces suffused with pervasive sexism amounted to wrongful conduct, right? That interfered with women's life opportunities and interests, right? Being able to be seen not just as your genitals, but as a whole and fully integrated person. And McKinnon also worried that if we looked to tort law, that we would, in some sense, trivialize the problem of workplace sexual harassment, that it would be rather not seen as a structural problem, but rather individual, sort of trivial wrongs. And in part, Kitty McKinnon had learned she sort of changed her mind a bit, right, with the pornography statute, and in arguing for civil penalties. But the notion that tort law is not structural is one that feminists today, legal scholars, have resisted, and I think rightfully so. So I'm going to tell you a bit about the theory and practice of cyber civil rights and how it's vindicated both in theory and in practice. The recognition of wrongs, not only as setting norms for behavior, but crucially empowering victims. So about 15 years ago, we started to see attacks on individuals online, in particular women and marginalized individuals, with privacy invasions, usually the posting of nude photos without consent, and often with their home addresses and phone numbers attached, as well as alongside defamation. So the suggestion that individuals had herpes or other sexually transmitted infections and were available for sex. And at the time when I started writing about online abuse, the response was loud and clear, and not just from other academics, but from commentators, journalists, sort of really well-known actors, was that I was making a big deal out of nothing, that it was just frat boy, rants, that this was just boys being boys, and in fact, cyberspace, and let's do that cyberspace, right, had its own rules, right, that it had its own norms, and that you don't want to break cyberspace with the notion that we can bring law and law development into play. And so at the time I argued, so in 2008, I wrote a piece called Cyber Civil Rights, in which I argued that we should leverage not only civil rights law, but also tort law and criminal law to send the message that this sort of conduct was unacceptable. It wasn't a triviality, it wasn't no big deal, right? But it was wrongful conduct that interfered with women and marginalized people's well-being, right? Their ability to have personal integrity, to be seen more than their genitals, right? That they were full people, to be free from emotional harm, the potential for physical damage, right, as people confronted them offline, and to make a living, right? And it was key for tort law in particular for victims to not only to see themselves as having been wronged and to feel empowered, that they could use and leverage law to vindicate their interests and to declare not only that they had been wronged and thus see themselves as being wronged, but make clear that they weren't going to be shoved in a corner, silenced, driven offline, but instead they were going to bring lawsuits. And about a year after, I wrote a book called Hate Crimes in Cyberspace. And a year after the book came out, two partners at K&L Gates, Elisa D'Amico and David Bateman, created what they called the Cyber Civil Rights Legal Project, which was a call to represent pro bono victims of invasions of sexual privacy. And within a day, they had 100 cases and couldn't take more. But I think two cases are particularly instructive for the practice of the recognition of wrongs. In a case involving a woman, a law student in California, her ex, after they broke up, emailed her nude photo to all of her classmates in her law school, to her parents, to her summer employers, this is after her second year in law school, and posted it, of course, on Facebook and Twitter, her nude photo, as well as on adult finder sites, putting up ads that said she was available for sex. She's a prostitute, and here's her home phone number, and she's interested in rough and anonymous sex. And don't bother to call, this is where I live. And in the lawsuit, the defendant initially showed up. He answered the complaint, he showed up for some discovery, but then sort of retreated, and the judge issued a default judgment. And you might say, okay, well, default judgment doesn't tell us very much. The order probably just says, and so in the order of what's claimed, $6.4 million. And instead, the judge wrote an extensive opinion and order in which the judge explained, federal district court judge in Central District of California, that these invasions of sexual privacy and defamation was the most vile conduct imaginable, and made clear that this was wrongful activity, right? Didn't have to spend paragraphs doing it, but the judge did. And in another recent case, interestingly, in state court, again, very similar facts, except it's not a law student, it's just someone, a nurse. K&L Gates brought a lawsuit on behalf of the victim against the perpetrator. And it was in a state in which the jury heard the case, the defendant appeared, and where you don't submit how much you are so asking for, right? It's up to the jury. And the jury came back with an $8.9 million verdict. And as Elisa D'Amico, the lawyer on the suit, explained to me, and she does this all pro bono, like right in her off hours, which I don't know how she sleeps, but she explained that not only was it was clear that the jury was sending the message that this was wrongful conduct, but that even though her client knew she'd never recover the $8.9 million, the perpetrator barely had a job, but she felt seen, she felt heard, and she felt like she had power, rather than being told that she was trivial and there was nothing to be done. And so here is just some minor critiques, I say this with great love, that the book, of course, is so heavy on concept, and brilliantly so. but short a bit on some of the practical impediments to this magnificent use and important use of tort law. And I'm so glad to be in front of, I always say this, my BU students and wherever I speak. We've got a room full of future lawyers, right? Future lawyers who may work at firms and who can take on pro bono cases. We simply do not have Elisa D'Amico and Dave Bateman, but not enough to go around. So we have thousands of people who at the Cyber Civil Rights Initiative, where I'm the vice president, who file complaints with us and say, help. Right? And there's only so many pro bono lawyers we can connect them with. So this is a call both to read the book, but also to kind of think about those practical impediments to make manifest and meaningful the recognition of wrongs and empowerment of victims. And as I was reading it, I also thought about, I'm a civil procedure professor. So I thought about how the substance of conceptual pragmatism should inform procedure. And in particular, especially given the tort law's manifest devotion to equality, that what we've seen in litigation involving victims of non-consensual intimate imagery is that they're often forced to sue in their name, right? And denied the opportunity to sue as Jane Doe's and sometimes John Doe's. And that if we understood rightly that the entire system should be understood with shaping of social norms and equality in principle, that to do that we also need to take your theory and invest it into procedure, even though, as I tell my students, and as surely your CivPro professors tell you, procedure is supposed to be trans-substantive, but we know in fact that will often be quite costly, especially to the most vulnerable. So with that, thank you so much. And Ben has been the longest of long-term mentors and friends, so that this is particularly delightful for me to be invited to be here with both of you. Thanks.
To echo what Danielle said, this is a fantastic book. It's extraordinarily readable, and that's not always true in any aspect of legal writing. So it really is something one could realistically read. And I think it's great that the library put on this fantastic event and that there are so many faculty, students, community members, staff, people from all over the university here is really a great tribute to Ben and John. So that's terrific. It's worth noting that this is also a collaborative book. And Ben and John's collaboration is, I think if you think about it, one of the most generative, creative, long-running collaborations anywhere in the legal academy. You know, there are a lot of fields where collaborations between famous co-authors are pretty normal and consistent over careers. Economics is one, but political science is another. Law generally isn't, and so that's also something worth acknowledging and celebrating. And it's also particularly incredible because they must be finishing each other's sentences, because the book doesn't sound like it was written by two people. It sounds like it was written by one hive mind. And in the spirit of collaboration, I just want to say that my comments are informed by a long conversation with one of our most brilliant students, Priya Menon. You can't blame Priya for anything that I say, but if there's anything good in what I have to say, it was probably Priya's in the first place. Okay. My comments are going to fit in somewhere between Danielle's extremely inspiring account of what civil recourse can look like operationalized, and Frank's more philosophical, though positively philosophical, account of the political legitimacy aspect. So I'm going to be somewhere in between. And I could title my brief remarks something like, Some Worries About Relationships. So in particular, it's important for Ben and John's book that torts are what they call relational wrongs. And by that, and I'm quoting them here, torts are wrongful as to a particular person or set of persons. So I'm going to say three interrelated things that are all worries about a system that says that by virtue of the tort, there is some relation between the parties, and that in civil recourse, we're going to use that relationality. So let me start with the question of accidents. So the first 100 pages of this book are an extended attack on Oliver Wendell Holmes Jr. And that's sort of impressive because, you know, this is Harvard Law School and Holmes is still a big deal, a century after his most important Supreme Court opinions, and 140 years after he was on the faculty for 30 seconds. And, he's still a big dominant figure, and so it's kind of impressive that they take him on. They take him on a range of different points, but one point where I'm not sure that they fully respond to his concern is with respect to the accidental nature of accidents, namely the idea that in an accident, there isn't necessarily a moral relation that could be said to exist as between the two persons or two parties involved in the accident. By virtue of the fact that it is accidental, and in an increasingly complex industrialized world, the world that Holmes was thinking about, there were more and more nearly random, nothing is truly random, and nearly arbitrary, nothing is truly arbitrary, encounters of which accidents were the primary type. And in that environment, it was plausible for Holmes to begin to explore whether we should think of torts as moral wrongs, in part because it's not intuitively obvious that every accident involves the morality of wrongdoing. In fact, I would argue that if there's one insight from Holmes that has been definitive in creating the world that Danielle is describing, and which the book describes, where you're not allowed to call tort a law of wrongs, it's this problem. It's the question of how could you create moral relations between people who bumped into each other by accident? And of course, there are many efforts to do so, and I think Ben and John do address that, but it's striking that in their account of the version of tort that they're rejecting, say the learned hand, the famous learned hand formulation, which is derivative of Holmes, it's just Holmes's ideas with present value analysis applied to them, they don't really address that model. They're not that interested in it. I looked it up, and I didn't come across the learned hand formula except obliquely once in the book, and then I looked in the index, and sure enough, it's not something that they discuss at length, but it's an attempt by learned hand to say, in a world of accidents, all we can deal in are probabilities, and we therefore can't obviously ascribe a moral theory. Now, I can imagine a way to do it, but I would like to hear more about how they think about that. Second, and this goes very much to what Danielle was describing, when you say that tort is a law of wrongs that are relational, to some degree as a moral matter, you're imposing a relationality between the victim and the person who does the harm. Let me say that again. You're imposing a moral relation. Now, sometimes, as in the cases when Danielle is describing, where people feel very wronged by another and are very wronged by another, they will find it empowering, as in Danielle's examples, to be able to go to court and say, I was harmed, and they will be able to feel seen, as Danielle said, when they receive some redress from the courts. But there are lots of circumstances where a person who has been harmed will not want any relation of any kind with the person who harmed her or who harmed him. Now, this may be less in the case of accidents. This is a different objection than the accidents case. But imagine a case of sexual assault where the victim of the sexual assault wants never to see the assaulter again, wants to have nothing to do with that person, certainly believes that someone should be in charge of punishing that person, that someone should be the state, but does not want to feel that it is her burden in any way, shape, or form to be involved in that process, and certainly not her burden that if she wants civil redress, she must go into court and, whether anonymously or otherwise, take a stand blaming that person morally and demanding recourse. So it's not just a question of anonymity, as Danielle says. A person might well say in that situation, I don't think I should have to sue at all. Not I shouldn't have to sue in my own name, I shouldn't have to sue at all. In a tort system, one of the functions, the functional effects of a tort system is that although the state may address the criminal matter on its own, if the state is also saying the only way to get civil recourse is if you bring the lawsuit. Now, if you imagine an alternative system, and you can imagine it exists, for example, in Sweden today, where the state criminalizes even conduct that we would consider merely to be tortious sexual assault, you can imagine a scenario where, from a certain person's perspective, that would be superior. Now, again, I would add, I believe it would be nice for that person to have the option, or good, desirable, morally desirable for the person to have the option, because if the state doesn't vindicate your rights, that might be very frustrating, and you would rather have the option to do it yourself than for the state not to do it at all. And there may also be cases where people have a strong moral desire to be the one to go to court. That's totally plausible. But I think there's something more than that in the theory of relational tort, I think it effectively and functionally in the world obligates you to have a relationship with the person who has harmed you. And I can imagine a version of a very strong feminist objection, doesn't have to be feminist, but a very strong objection to that formulation. And a concern that it forces you into a situation where the only way you can get recourse is if you do it yourself. And with that, I just want to close by mentioning my last worry, which has to do with more closely with Frank's concerns or issue about the political legitimacy and the idea that a system to be a just democracy should have something like civil recourse. I think I'm really skeptical of that for the following reason. I think if you had a system that consistently, effectively, and fairly managed to compensate people for wrongs that they had suffered, and did so by a system that was not relational, but actually did it, that would satisfy the demands of political justice. So what I'm describing is a scenario where if you're injured, you will be compensated. You actually will be compensated. If you've been criminally injured, the state will vindicate your rights by criminal action. And although we have an instinct living in our society where the state doesn't do that, to say that naturally we need to be able to appear and do it ourselves, that's partly because we don't live in a society that thinks that it is the state's job to vindicate all sorts of wrongs. So I'm not convinced there is an argument in the book about this, and I would like to hear Ben and John say more of it, but I guess what I'm trying to say is, it seems to me like an accident, no pun intended, but to bring it full circle, an accident of our system, that we have these divergent criminal systems where the state vindicates your interests, and a civil system where you vindicate your interests. I mean, at one time, private parties could bring criminal cases in common law countries, but then the state came to monopolize that function. Similarly, there are lots of countries in the world, maybe not lots, but a reasonable number of countries in the world, they're more statist than the United States, where the state does take seriously the personal wrongs that you've suffered, and the state will compensate you for them, and the state will punish either by demanding some form of recourse or redress itself, or punishment of a direct kind from the person who wronged you. And it seems to me that that system is perfectly consistent with political justice. Not only that, but under some conditions, for some people, might actually be a superior system. So that's my last worry. And I want to echo everyone else in saying the book is fantastic, and it's an honor to have a chance to participate in the conversation.
We need a minute.
The hive mind.
I think you have to talk in unison.
I'll say the first half of each sentence, and John.
You're seeing it in action here. It's kind of cool.
There we go, the hive mind working.
I thought you might want to do that. I'll give it to you. Okay.
We're done.
So Noah got John and me most riled up. So it is the privilege between us to get to be the one who responds to Noah, and I gave that privilege to John. So I get to start by saying something a little mean. First of all, thank you to Harvard for hosting this event, and to the library, and thanks to all of you for coming. The mean part is that, you know, John and I are very interested in Holmes and Cardozo, but since John's the one in Massachusetts, we'll call him the Holmes one, and since I'm the New Yorker, I get to be the Cardozo one. I just want to say a few things. Principally, I guess I want to talk for a couple minutes about constitutional rights and about Rawls and Dworkin. So Frank and our mentor, Ronald Dworkin, I would say are probably the two figures most closely associated with having translated in some sense or adapted in some sense Rawlsian thinking about political theory to the legal and in particular the constitutional domain. So I don't think it's surprising that Frank finds in our work a reflection of Rawlsian themes given of that historical backdrop. So let me be greedy for a moment in this response, which was, I mean, it was, how do I put it, ludicrously flattering, what Frank said about the Rawlsian theme. But let me be greedy and take a little bit more, saying he didn't go far enough. Okay, so from the point of view of American constitutional theorists, I think what is exciting about Dworkin's use of Rawlsian themes, and it's not that Dworkin was a Rawlsian, but there's a strong parallel between them. What was exciting about it, and is exciting about it, is exactly what is highly problematic about it. And what's exciting about it is that if there's a kind of constructivist, and here, although Dworkin didn't use the term constructivist, he kind of was a constructivist. He probably ought to have used that. But what's exciting about it is you get to exist on this metaphysical middle ground, which is you're not a natural law theorist. You're not saying that these values and rights are somehow wired into the very nature of the universe, but you've got a way of saying that you're anything but a legal realist, and there is some kind of truth and knowledge here. So that is a big part of what is exciting about constructivism, and it is in meta-ethics what's exciting in part about Rawls too, about the idea of constructivism. And yes, we did select the word constructivism with exactly that in mind. But what's exciting about it is also what's problematic about it. So we love this as to constitutional rights because somehow if you're Dworkinian enough, you can tell the story that the justice is sitting on high. They're not Platonic guardians. They're not finding the forms of morality because we're not doing something quite that metaphysical. But whatever their lawyerly and cultural training is, they actually are experts. They're actually in the right place to find this answer, and because Rawls and Rawlsian theory tells us a story about actually why there are rights-based conditions on legitimacy, they're actually doing something that is justifiable from a political theoretic and a constitutional theoretic point of view. That's the way Dworkin read Rawlsian theory, broadly speaking. And of course, that's what everybody gets upset about, because then the power of judicial review is not only great, it's mighty. It's literally, as Dworkin called it, Herculean, and that scares people. So the sort of self-aggrandizing thing to say is that part of the reason John and I were attracted to torts, and we started working together in the first week of law school, literally, when we met in our legal writing section. Part of the reason we were attracted to torts and to Cardozo is that the judicial enterprise of engaging in constructivism about rights and duties is far less scary in the common law of torts, because there is, I mean, John has written nicely about qualifications to this, but there is basically very ample legislative override of what can happen in the common law courts. And that gives a sense of sort of freedom about engaging in recognizing wrongs, that's the name of the enterprise we're trying to name in this book. Judges trying to find these things that exist in culture and in the legal system and are also sort of right. And I think that's a safer enterprise in the common law in some ways. And of course, Cardozo spent much less time on the Supreme Court than Holmes did, and the Cardozoan tradition is much richer in the common law than it is in constitutional law. Let me just say briefly that just pick up one thing that Noah said and combine it with what Danielle was saying. So I think that Danielle's challenge to, once you do recognize these wrongs, and once we see them as legal academics, and some judges see them and some legislators see them, how is it really going to happen in our world? Isn't that what we need to know about? And we don't say enough about it, and I agree with that. But Noah said something in a way complementary to that, which is that it's very troubling that people have to do this themselves. Wouldn't it be better if the government did it for them? So my own aspiration would be the same one that Danielle articulated. And as was mentioned, part of my work is as a legal profession, legal ethics scholar. My own aspiration is that both in torts generally and in cyber civil rights, lawyers and the legal profession have a huge role to play in making this happen.
Great, thank you. Thank you all for your very kind, charitable, and fascinating comments. I'm going to respond to Noah aptly by invoking indirectly my love of the writ system, which always scares Liz Kamali whenever I mention this, but because I don't really understand it. But I think the idea is I'm going to give, in response to Noah, 2 denials and 1 confession and avoidance. First denial about relational wrongs and the idea of accidental harms not being relational. Obviously, a lot depends on what is meant by relational. Certainly, we are a world that is increasingly and perhaps problematically a world in which people interact as strangers, and in that sense are not in thick personal relationships. But of course, that's not the sense of relationality we're referring to at this point in the analysis. What we mean by a relational wrong is conduct that is wrongful as to some person or class of persons. And so when you're driving along on the highway, and this never happens in Massachusetts, but a complete stranger cuts you off, you have been wronged by that stranger. Even though they are a stranger to you, they have misbehaved with respect to your well-being, your interests, and you can say, hey buddy, I don't know who you are, but that's no way to behave towards me. And in that sense, I would deny that interactions between strangers are non-relational in a significant sense. They are relational in just the way we care about, which is it's a way of mistreating another person by driving badly in their vicinity. Second denial, and this connects to what Ben just said at the end of his remarks, I don't think it's right to describe our thinking of torts as a law of redress for wrongs as imposing an obligation or a moral relation on persons. A big part of our story is that what recourse is all about is empowering victims, as Danielle suggested, and part of what it means to have a power, and now we've got to go Hofeld, but part of what it means to have a power is that it's your option, basically, whether or not to exercise it. And so certainly it is true that one of the benefits, but also one of the drawbacks of the tort system is that it's, in a sense, optional. And in fact, overwhelmingly, it looks like the empirical evidence suggests the vast majority of tort plaintiffs, that is people with valid tort claims, never exercise the power. What do people do with the tort system? Mostly nothing. Because there's lots of reasons, some good, some bad about why they will or won't sue. So there's no obligation to sue. Now, that doesn't mean we don't have a problem. As Danielle suggests, a lot of what our work is about is thinking through why it's valuable to empower victims of wrongs to be able to respond to those who have wronged them. And that goes hand in hand with thinking hard about procedure, lawyers, and that's another aspect I wanted to point out. Why do we have lawyers? They're just a big drag on the economy, right? They're just
I always say so.
I'm sorry, you're all just a big transaction cost. No, I mean, one of the things lawyers do is they stand in for people, right? And so ideally, and this is very idealized and at a very high level of abstraction, what a lawyer can do for some people and some victims is represent them. That is, stand in for them and assert their claims on their behalf. And that's one of the reasons why we have a system of legal representation. Okay, finally, confession and avoidance. Quite right that were we tomorrow to wake up and become Sweden or Norway or New Zealand or whatever the relevant jurisdiction is and switch to a system of compensating injury victims without lawsuits and maybe criminally prosecuting the most awful among us. Have we left the building? Are we no longer in a liberal democracy? That is not our position, and I think it would be a silly position. I'm prepared to say that Sweden is a liberal democracy. I've said it here on record. But I do think we've changed, and we've changed our system not from a liberal to an illiberal system. We've changed it from one form of a liberal democracy to another. And what we've changed is precisely the degree to which we're empowering individuals to respond to forms of mistreatment. Now, maybe on balance, we'd want to disempower people in exchange for other goods like faster compensation, less antagonistic relations, social peace. There are various goods that might come from this, but we'd also be losing something. We'd be becoming much more statist. Now, we're relying more heavily on government officials to do the things that ought to get done, like vindicate the interests of victims. Now, there's nothing wrong with statism. We are not libertarians, or at least I'm not, and I don't, last time I checked, you're not. So the point is not that the state is bad. The point is that state official action has its own dynamics and its own problems and its own puzzles. And so what we have to ask is, on balance, do we want a world in which we have more state power and less individual power, and the goods that comes with that and the bads that come with that, or a system where individuals have more power, but that comes with costs and benefits? So thank you all. Incredibly helpful comments. I think we have a little bit of time, 10 minutes or so. I know a lot of people have to leave for class, and obviously feel free, but I think there's some microphones in the audience, so if people have questions, we'd love to hear them.
Thanks for this great conversation. One thing I was wondering if you could talk a little bit about continuing the theme that Noah and Danielle brought up on the subject of restitution in criminal law. So if the considerations are relationship, considerations are redress, it seems like in restitution we have both of these present, the difference being that this, again, gets to the point of it's initiated by the state in a criminal proceeding. And I'm curious to hear whether your approach is, would tell us one direction or another, whether this is a positive, a negative, a blurring of lines that should be present, whether we want more role for perhaps victims in saying whether restitution is something they want to pursue. Does this have implications or directions for the criminal overlap there?
I think that our view generally goes along with a variety of kinds of distinctions between tort law and criminal law. One of the things I've written a lot about is punitive damages, because and restitution in criminal law is in a way the converse of punitive damages. I certainly think there's a role for it, but I think there's a variety of different kinds of due process analyses that go on, depending on whether it's individual as against the state or individual as against individuals. I do think that, in fact, it's one of the good things in criminal prosecutions that once you've actually proved by a criminal standard that there's a crime took place, I think it's actually great to have the state's assistance in making sure this happens. But your question gives me reason to raise one other concern about Noah's comments, which I wanted to mention, that also tie in with Danielle's. This is not all about money, and it's not all about compensation for physical injury. Part of what's important about tort law is that there is a range of rights against mistreatment by others that tort law recognizes. We both talk a lot about defamation and privacy invasions. And one of the things we can do in a system that does not have the state coming after you directly is we can recognize, I think, a wider range of wrongs with more easily than otherwise.
Thank you so much for this wonderful panel. I also want to thank especially Professor Zipursky, who's been my mentor for so long. So my question is about tort law reform that we see in the US, and I'm wondering that actually in contrast to what's happening in New Zealand and elsewhere, it feels like an attack to tort law and recognizing wrongs. How does your theory respond to this movement in the US?
That's a great question. Thank you. This book is very much fueled by a response to a number of sort of assaults on tort law, and one of them is the tort reform movement, which we think it's a complex economic and political phenomenon. Some of it is just rank economic self-interest and the desire of certain powerful people and entities to not have to pay for the bad things that they do. But some of it is tied to a misconception of what tort law is all about. And our hope is that by recapturing what people used to sort of what lawyers seem to understand pretty intuitively 100 or 150 years ago before the nefarious Holmes arrived on the scene, by recapturing that, people would have a better understanding of what it means to reform tort law, what is gained and what is lost by doing so. The easiest way to do tort reform, if you're an academic and have thought about tort law, is to say, well, I know what tort law is. It's a terrible system, a really inefficient system for insuring the costs of accidents. If that's your view of tort law, then tort reform is almost a logical implication of that view of tort law, because why would you want a terrible system of insurance when you could have a better system of insurance? If, by contrast, you actually understand tort law to be empowering victims to respond to wrongs, then you would realize that insofar as you take those powers away, you are denying people certain basic powers or liberties that might be really important within a liberal system of government. Maybe one more question? Don't be shy. No? Okay, good. Well, thank you so much for coming. We really appreciate it.